A very big warm welcome to all of you who've dialed in today, and a special hello also to those of you who'll be watching this webinar later on as well too. We'll be sharing this webinar available to a number of parties who've expressed an interest but who couldn't make it today. So I'm Lynda McAlary-Smith and I'm Victoria's Small Business Commissioner. I'm also joined today by Nick Edrington, who is the Victorian Small Business Commission's Senior Communications and Engagement Advisor. I'd like to start our session today by, of course, acknowledging the traditional custodians of the lands on which we're meeting today, and we're coming across right across the great state of Victoria today. I myself am here in Melbourne, so I would like to acknowledge the Wurundjeri people of the Kulin Nation and pay my respects to elders past, present and emerging, and especially welcome any of our Indigenous colleagues who are here with us today as well too. So we're going to share a lot of information with you today about farm debt, all things farm debt. Now, there is going to be a lot of content, so don't worry, we will share the slides with you afterwards. If you are watching the webinar after today, at a later point in time, please reach out to us for the slide deck as well too. So you'll have the slide deck as a reference for all of your content. So look, without further ado, what I'll do is I'll dive into the content because there is a fair bit to cover. I will start by explaining the context of farm debt, mediation process in Victoria, how it came about, how it works, from a range of different perspectives as well. So we've got 45 minutes, I think, for our session today, if I've got that right. Nick, let me know if I've got that wrong. So I'll endeavour to move through it relatively quickly so that we've got a bit of time for Q&A at the end. So in Victoria, having farm debt mediation, the service provided with the Small Business Commission, is unique to across Australia. It's not that there are not other jurisdictions who also have similar schemes. Victoria's is a compulsory one, and also it sits with the Small Business Commission, which has proved historically to be a really successful model. In some other jurisdictions, depending on where your work takes you and who you're dealing with or supporting, in some other states there are compulsory schemes, others it's voluntary, and they might sit with others within government. So the Farm Debt Act has been in place since 2011, and the whole heart of it, the soul of the intent of the whole scheme, is around giving an opportunity for farmers and their families to be able to sit in a constructive environment with their financiers to try and nut their heads together to figure out a way through when the farmer is experiencing significant financial difficulties. It comes out of really turbulent and sad times at the time, and unfortunately it was one of the policy reasonings behind it was unfortunately a high number of deaths by suicide in farming communities at that time. We are really conscious that still remains an issue. So we take great pride in providing the support that we do through the Farm Debt Mediation Service. So the idea is effectively, because of the unique situation that our farming families and farming businesses are in, the nature in which they're connected to their families, often intergenerationally, and also the importance of farming to their local communities and indeed food and fibre more broadly in terms of security of food supply, that it was really important that farmers had a special mechanism to receive help when they needed it. And of course, we've seen, as we always do, the various natural disaster events which happen and unfortunately now seem to be occurring with greater regularity. So the availability of this support is never been more important. So there's a couple of things I want to cover off in terms of what farm debt covers and what it doesn't. Sort of in plain English, effectively, a farm debt is a mortgage against a farming property or machinery that's used for farming purposes. So, and the definition of what's a farming operation, you can see there on the screen. So I won't take it through in a detail. There were some changes a couple of years ago which expanded it out to include aquaculture as well, amongst other things. So if you've understood farm debt in the past and maybe not for a couple of years, I just encourage you to have a squeeze at the current operation, because it is intended to pretty much cover every type of farming operation. One thing that is really important, that it has to be for the purpose of a farming operation. The debt is for that purpose. So a debt, for example, to do a renovation on the family home that was in no way connected to the farming operation would not in and of itself itself be a farm debt, whereas getting securing the property to, build some grain stores or barns or buy machinery could fall within the ambit. And it does need to be a commercial farming operation. So we saw obviously COVID, a lot of people relocate to greener pastures. So if people are running, what we might call colloquially a hobby farm, they would not be covered unless it's actually a commercial operation. We do sometimes get those questions where there is a little bit of jurisdictional debate over whether or not it is actually predominantly for a farming purpose, and we judge that always on a case-by-case basis. So the Small Business Commission was established over 20 years ago. So we're an independent government agency. So we are funded by the taxpayer, but we are independent of government. We're not a government department. We don't take the directions from ministers and the like. So we are effectively have been created as a safe space to advocate for small businesses, of which farming is obviously a big chunk of that, and also provide a safe space to provide alternative dispute resolution, which I'll talk with you through the session. It often involves no fee and sometimes a nominal fee to access as well. Effectively, the heart at why the Commission was set up back in the day and remains with bipartisan support is to level the playing field when there is an inequity in bargaining power in a business context. And obviously small businesses are predominantly on the receiving end of that, and farming is no different in terms of when you're dealing with a financier, particularly big banks as well. So in terms of our responsibilities under the Farm Debt Act, we need to do what we're doing today, which is explain, of course, how it works, provide support and assistance to both farmers and creditors. And we've developed a number of templated forms, which indeed parties have to use in order to access the process. And we've also got statutory responsibilities where I can issue certain certificates, which I'll go through in a bit of detail towards the end of the presentation as well. But that independence is really important because we don't represent the farmer, we don't represent the creditor. We're here to provide an independent, impartial, safe space, which sometimes can involve or always involves giving TLC, particularly on the farmer's side, and sometimes with a sprinkling of tough love to both the creditor and also to the farmer as well. So the certificates that I just referred to, there's two types of certificates under the Farm Debt Act. And again, if you've played in this space previously, but not so much recently, a prohibition certificate is a new certificate, which was introduced a couple of years ago. What an exemption certificate effectively means, when I'm explaining it in conversation, is before a creditor can take enforcement action, and that could be foreclosure, that could be, filing proceedings in court. Before a creditor can do that, when the debt is for a farming operation and also for farming purposes, so it falls within the Act, before a creditor can actually do that, they effectively need to get permission from me to say that they've exhausted the alternative dispute resolution options. So when it talks about an exemption certificate, the clearer way probably to think of it in your head is it's a permission certificate. The language of exemption is that the exemption is that they're seeking is to then be exempt from the application of the Farm Debt Act for 3 years. So effectively, it's a permission certificate to let a financier move forward with enforcement action for a period of 3 years. But that's why it's called exemption certificate. Prohibition works exactly the other way in the sense that, and it's the new one, which is the farmer can come to me, and if the creditor hasn't been doing what they're meant to do under the Farm Debt Act or doing it in good faith, a farmer can come to me and say, I want to get a prohibition certificate. That then stops the financier from being able to take any enforcement action. So they're kind of both sides of the same coin in a way, and the prohibition certificate, the policy intent behind that was to put farmers in a position where if they are having a situation where the financiers are not engaging with them in good faith or at all, that they can actually bring them to the table to say, no, I've got a prohibition certificate, and feel protected for that period of time, rather than hoping that when the creditor applies, I will then go, no, I'm not going to give you an exemption certificate. But the prohibition certificate doesn't really create new rights for a farmer, because I should only be issuing an exemption certificate. That's the same test, effectively, plain English, that I should only be issuing an exemption certificate in a circumstance where a prohibition certificate would also be appropriate. So if they're not mediating in good faith, or they're failing to mediate, they should not make it over the hurdle to get an exemption certificate. So it's an extra surety that's in place for farmers to give them that peace of mind in what is a really difficult period of time in their life, of course. So what does the process actually look like? And I'll assume varying levels of understanding about mediation, because if you haven't been exposed to it, haven't been participated in it, you're not expected to know what it works, and it can be very different to what you might have seen on TV. So in terms of initiating the mediation, so creditors can apply, which is generally the pathway that happens. The creditors can apply to us, to VSBC, for mediation assistance when the farmer is in arrears for their farm debt. So one thing that's important to note is that farmers don't need to be in arrears to apply to have a mediation. And that, again, is a bit of a change. So the way it used to be was that if a farmer wanted to have conversations pre-falling into arrears, probably because they expected they were going to, but hadn't yet, what the new changes, a couple of years old now, have set up is that if a farmer's in arrears, they can come and access our service to have mediation with the financier. Hopefully that's successful at charting a way forward. If then, subsequent to that, the farmer falls into arrears, that first one doesn't count for the farm debt mediation process, if that makes sense. So if the farmer goes early, so to speak, and tries to resolve it, and then down the track they fall into arrears, the bank is required, the financier is required to actually go through the farm debt mediation process again. The thinking behind that too was, if a farmer has an incentive to actually go early, to have early conversations, it doesn't then prejudice them down the track, because if it does fall into arrears, there can still be great value in having a mediation, as we know from our general work. So again, that's a little bit of a difference if you haven't been involved in this space for a little while. And that's a really important point. So it's not that it's one go and then that's it. That if you go early, which is encouraged as a farmer, that then you can have another one down the track as well if you need to. So a creditor-initiated mediation, which is the vast majority of what we do, and we provide template notices that are available to creditors and farmers, and they're actually obliged to use them. I have at times, where they transitioned a couple of years ago when we had some changes, and I will review every application for an exemption certificate, and if the financier has used the wrong form, I reject it. And so they've then got to go back and start the entire process again. And the reason for that is not being officious, but that once the forms change, they've been gazetted. So therefore, they are the only lawful forms which are able to be used. So one of the old forms is no longer valid. So if you are working in that space where you have a role in this space, really make sure that you're doing the current versions of the forms. Some people have old templates saved on their hard drives and things like that. We worked really heavily on promoting all the communications and stuff at the time, so it only happens now very rarely. And if you're in doubt, just reach out to us and we can make sure you've got the right ones. One shortcut is to see, does it only reference Small Business Commission? Victorian Small Business Commission is a good steer, because the old ones referred also to Department of Agriculture as well too. Predecessor names AgVic. So the farmer can, so if the farmer's in arrears, and usually our experience is this comes some way after there's been numbers of attempts by the financiers, particularly the larger banks, to actually try and engage with the farmer. So we don't often see a situation where a farmer is in arrears for 21 days and then all of a sudden, the farm debt process. Usually particularly the first tier lenders are taking a number of steps before they get to the point of having to have use these forms, which is again just a reminder for those of you who are either in farming or supporting those who are, the importance of having conversations with those who you owe debt to. If you are struggling and you're forecasting you won't be able to meet your obligations, and that doesn't just extend to who you might have loans with, it extends to the ATO as a a prime example either. The worst thing you can do is not engage. You force their hand when you don't. So if you are struggling, or you're supporting people with debt who are struggling, or they're worried that things are not going how they'd hoped, having those conversations early you're always in a much better position. You have more choices, more options than waiting for, say, the bank to drive up the road or the ATO to come and knock on your door as well. So the farmer's notified, we'd like to, you're in arrears. That should not be news to them. They receive a form that sets out and other paperwork, and there's educational material from us about the whole farm debt process. If the farmer says, yeah, okay, I'm going to have a farm, I will take you up on this offer, I will have the farm debt mediation. That's when we jump in to organise the actual mediation. Now, the Act does actually allow financiers to organise alternative means of having a mediation, and we sometimes see that, particularly where you've got farming businesses with businesses in different, like with assets in different states, or you've got they've used other means. So I have the ability under the Act to look at a mediation that's taken place, not with us, and form a view that it's been done under another alternative dispute resolution scheme, and that's okay. This is all designed to be really pragmatic. So this is not an officious process that's ticking boxes or what have you, that it's designed to be really meaningful bringing together of two parties to discuss what is a really difficult situation. And then our staff who are specialised in this area will contact both parties to organise a time, and the farmer doesn't have to accept it. We obviously try and encourage farmers to do it, because in our experience, getting to have an insight into all of these mediations that we do see that there is absolutely value in having the conversations with your financiers in this setting. We make sure that the mediators who are doing the mediations are expert in this area. They get it. They get your context. You're not going to have someone in there who has no idea how a farming operation works or doesn't get the often intergenerational impacts, pressures and challenges either as well. You'll get someone who has worked in this space before. So you're not having to sort of, explain things that you shouldn't have to, and also so that you can have someone who understands what you're feeling as well too, which is obviously very important. So then if we move then along to what then happens if the farmer doesn't mediate. So the farmer doesn't have to mediate. The bank has to offer it. The financier has to offer it. The farmer doesn't have to. Sometimes we find the farmer doesn't respond either to the financier or to us, or sometimes the farmer just doesn't see the utility in it, or isn't in the headspace to do it as well. So there's different timing and thresholds, which you can see on the slides, around if the farmer either declines to mediate or the farmer fails to respond as well. There's a time period that then kicks in, that then goes, okay, the creditor is allowed now to apply for one of those exemption/permission certificates from me. And the exemption certificate they have to have it. So if it's covered, if the loan facility is covered by the Farm Debt Act, they're not allowed to take enforcement action without it. So if they didn't, and they ran off to, say, the Supreme Court or Fed Court, whatever, it will get bounced out. So it's those of you who are advising in this space, it's really important, obviously, to be aware of that, in case you do have ones that come across your desk and maybe one of the financiers hasn't gone through the right process. In our experience, particularly around first-tier lenders, it tends to be a well-oiled machine from understanding their responsibilities across the country, but not always the case with some financiers as well. So if either you are thinking about, well, I'd like to maybe access this process myself as a farmer, or you're supporting people who do, and look, just a massive shout out to our colleagues in the rural financial counselling space, who are, absolutely superstars. They are incredible service, and the understanding and the empathy that they provide is extraordinary. And again, the expertise, the amount of people I've spoken to in the rural space who have experienced just the relief of being able to have the conversation, get it all on the table, even if you're mapping out what might be your very worst fears of what's happening in your business and family life. Having someone who's there who can say, okay, well, this is it. what's our pathway forward to start to take control of that, but also to have a really supportive person there to have an ear and support you as well too. So any rural financial counsellors on the call, just keep up the amazing work, because I know it takes its toll on you as well. So a farmer wants to come, and we do get this sometimes. So they've got different, being legislation, there's different forms they have to use, but it's basically the same thing. It's effectively a formal mechanism to say to whoever they owe the money to that, yes, I want to go through this the farm debt process. And the same thing is true around creditors having timeframes to respond, and so that in almost every instance we would not be in a situation where the creditor is ignoring it, and if the case, we normally get an answer out of them relatively quickly. So, well, what if the creditor doesn't agree to mediate? Well, that's when those new prohibition certificates come in, and that's where I think the prohibition certificates are it's a safety gate for the exemption certificates, but also it is a bit of a protective thing for our farming businesses, so that they can feel that if they are dealing with a creditor or an individual within that organisation who is not engaging with them or is being unreasonable and not dealing in good faith, that they've got something they can do about it, that they're not just waiting to see what the creditor actually does. I would say, and this is true of ATO as well as the financial organisations as well, if you are having a difficult experience with the person that you're dealing with in that organisation, and you're really not getting traction, you're getting a computer says no person, or just someone who is, not actually listening and actually being responsive to your circumstances. And that doesn't mean you always will get what you want. But if you really feel like you're just talking to a brick wall, shouting into a cave, what have you, do not hesitate to escalate that as well, because you're dealing with large organisations with thousands of staff. Some staff are better than others. Even great staff have bad days as well. So if you're really not getting traction, and the rural financial counsellors know this very well, don't hesitate to escalate up. And if you're in a situation where you're trying to do that and you're not getting traction again, don't hesitate to reach out to us, because we've got a great success at reaching into large organisations at very senior levels and getting traction almost immediately. So if we can help in any of that way, please let us know. So what does farm debt actually look like in terms of an actual process? So there's the mechanics of it. So being, adjacent to government, we love acronyms. So we have our DROs, which are dispute resolution officers. So they're staff employed by VSBC who are expert in this, have been doing this for ages, and they organise the mediation. So, they're there to lend an ear as well. As I said, they don't represent the farmers and certainly not the financiers as well, but they're there to listen. There's going to be no judgment. You don't need to be worrying about what you're telling them. And please, one thing I would say, it's natural to feel it, but there is no need to feel any sense of embarrassment or shame or reluctance just to share things. It's what we do. We're here to help you and receive that information in a safe space. Everything you tell us is confidential as well. We make it really clear at the start that if you're giving us paperwork, we're going to give it to the other side. And we do that through all our dispute resolution work. So you'll never be in a situation of having shared something and then, you've told them that and I wasn't expecting that. We're really clear about how things work from the get-go. And my staff, what gets them up in the morning is helping people like you. So our experience is one of the most powerful ways to get someone in the right headspace to participate in any kind of mediation is for them to be able to let it out a bit first, so that they can have a bit of a download of what's going on in their life and then move on to, right, okay, what are we going to do about this situation? So most of our mediations broadly at the Commission are all done online. But we've made an exception for farm debt, and farm debt we still do face-to-face, with the exception that if both the farmer and the bank are busting to do it online, no problems. We can certainly arrange an online one through Teams or Zoom, for example. But our default position is we prioritise our resources to doing face-to-face mediations for farm debt. We used to do all of them face-to-face, and then we learnt over COVID we didn't need to do that. And we feel for farm debt there is value if we can getting the parties all together in a neutral space as well too. Very rarely do we allow allow them to be held, say, in the bank's, the local branch. And that is only when we are 100% sure that the farmer genuinely prefers that as the option. We've got great networks through our friends in rural financial counselling and all across the local councils right across Victoria. So you don't have to, doesn't mean you have to come to Melbourne. If you need it in your local area, we'll be able to find a facility to do that. That won't be a problem. And you don't incur any extra cost for having it face-to-face and or in a different spot. We do sometimes find that farmers prefer to not have it in their own town for a whole range of reasons. So we do have facilities available in the CBD in Melbourne, but otherwise we can pretty much rustle up a suitable facility anywhere that's needed. So the fee's heavily subsidised. So it's $195 for a full day session, and the Victorian government subsidises the rest of that. If you were to go and get one of my mediators to do a mediation for you all day for a normal commercial dispute that you have, you'd be looking at around $5,000 a day plus extra for the prep work. So $195, and that's the legislation requires that to be the same amount to be charged per party. So the bank pays $195, and so would the farmer. And again, a massive shout out to always trying to enlist the rural financial counsellors or your accountant or your solicitor, and just making sure that you've got, for the latter two, you've got one who's an expert in this kind of space in this area. Sometimes our mediators find, depending on who their advisor is, there's better advisors than there are other advisors, to be crude about it. And sometimes our mediators are trying to, it's harder for them to be able to help the parties reach a cut through if someone has someone in their ear telling them stuff that might not be legally accurate, or might be, an esoteric legal argument that, if you had $1 million, you could go and argue in the Supreme Court, but by virtue of the fact that you're in this situation, you don't. So I just encourage you to make sure you've got the right advice team around you as well too. And looking after yourself as part of this process. So there's supports available, of course, through Beyond Blue and other mechanisms as well, because this stuff's really hard. And in farming, it's even more complex. We'll often be dealing with farmers who, very rarely are they the first generation farmers, and you've got a whole range of different things going on. Often all branches of families, a whole range of different ages are involved. Then you can overlay normal life events, marital breakdowns, deaths in families, difficulty obviously in trade, weather events, all this kind of stuff. So if you're at the point of needing help with either arrears or potential arrears, again, there's no shame in putting your hand up and saying you just need someone to talk to. So potential outcomes. So potential outcomes could be an agreement, so that the parties agree to terms of settlement. One of the ones we see very commonly is it's an agreement to sell part of a property or a property within the portfolio or the property. But within a certain time frame. So rather than the board being on the front and it making it clear that the bank's the one driving the bus, which obviously has the potential to impact pricing of the sale, that banks will agree and say, okay, you're going to sell it under your own steam, but you need to do it by this date. So there's an end date. It's not an endless thing. That is something we see quite a common way, which means then the farming business can manage how they deal with that, how they position it with the agent, how they promote it, and they're not. It can cut out a little bit of that stuff around people looking to kind of go in and pay you rock bottom because they know you desperately need it, and/or you're the ones in the decision point about how much you sell it for as well too. I mean, the banks obviously have ethical and legal obligations about, I can't accept ridiculous prices, but as we all know, if the market thinks it's a good offer and there's no pressure behind the sale, that will help when it comes to actually selling it. So it could be that. So often we'll see that it's an agreement. We do regularly see some degrees of agreement to forgive or not pursue parts of the debt. There's never ones when they walk out going, we get it, you've had a really hard time, don't worry about any of it. That's just not the commercial reality. But we certainly see a range of very beneficial terms agreed to for the farmers. And because of everything that we do is confidential, I'm a bit constrained about that. And I don't want to overpromise by giving you too many examples of things that we've seen, because it will always be case by case from the creditor's perspective, because they will have their rights and they will have what they're expecting and indeed entitled to be paid. But we do see flexibility around dollars, time frames, and as I said, context of sale or restructuring as well too. Sometimes it's a matter of agreeing that, you know, things are bad now, but because of X, Y, and Z, we actually think if we can just get through to this period, things will be better. So can we agree to kind of revisit things down there? Or it might be other situations where the farming business is agreeing to get in specialist advisors to help them look at costs or, you know, revenue streams or the technology investment and things like that as well. So I see a lot of great stuff come out of our farm debt mediation. So if you're advising people in this space, or you're wondering about, is it worth the time? Because I owe so much money and, you know, I'm not in a position to be able to pay it back. From where I sit, there's great value in dedicating the day to it, and the prep obviously beforehand if you can, because you might find that the options are better for you than if you did nothing at all. In terms of exemption certificate process as well, so once the you know, and sometimes parties can't agree to anything in the that's probably a bit rarer of what we see, because those who probably are not willing to entertain anything are usually the ones that won't respond to the bank, won't respond when we're reaching out to say, hey, we've received this request for mediation, please, if you want to mediate as well too. So for someone to actually, usually we've got the two parties in the room, usually there is some form of agreement, but sometimes there's not. The test under the Act is there has to be satisfactory mediation, which is a lawyer's picnic, right, that language? But what it effectively means is that the parties have mediated in good faith. That's just the plain English way of putting it, which means the parties have come into the room prepared to have an honest conversation, prepared to look at options and consider things. That doesn't mean that you're entitled to get what you want. Either party's entitled to get everything they absolutely want. That also doesn't mean that if one party relies on their rights and necessarily maybe you can't agree on any alternative arrangements, that by in and of itself doesn't make that party to be acting in bad faith. Bad faith goes to a range of different things in terms of behaviours, attitudes, all that stuff. So from time to time across our broader work, we do see some stuff around bad faith. A reflection I'd have connecting back to the right advisors is almost, in those handful of instances, it's almost always twinned to an advisor who is involved in the process, who I would sit there objectively and saying they're being unhelpful. So either they're winding up their party for their own purposes, or not giving them a realistic readout of where the person's at and what their options are as well. So there's some boring stuff around common law I won't bore you with about bad faith, but basically for it to be not in good faith, the bar is actually really quite high. And we generally find by the time we're actually having a mediation, of course, both parties are operating in good faith, because that's why they're there in the first place. So the certificate is 3 years. So that means, so one outcome we see fairly regularly is an agreement to sell the property within a certain, or part of a property or part of a portfolio, sell it within X period of time. And then what is also common as part of that is that will give the farmer a time to do that everyone's signed up to as being realistic. And what the bank will normally do is all at the same time apply for an exemption certificate, which means that, this is set out in terms of agreement, that if that's not met, so for example, you meant to sell it by 30th of October and you haven't sold it by the 30th of October, that then the bank has the exemption certificate to be able to move to enforcement action. So they can't do it any earlier than what's provided for in the terms of settlement, but then they don't have to go through this whole process again as well. So in terms of, as I said, the other outcome is there's no agreement at all, and again, as I've said, I've laboured a bit there around what actually is good faith, and farmers can absolutely apply for a prohibition certificate even if they've been in a creditor-initiated process. If then during the process of all of this, they feel like the creditor is not behaving in good faith, they can apply for a prohibition certificate. Another thing that's really important, which was implemented as part of the changes a couple of years ago, is that because the law requires me to issue the exemption certificates when the requirements are met. So farming debt for a farming operation, farmer in arrears, farmer either hasn't responded to attempts to mediate, or satisfactory mediation has taken place. Again, satisfactory is just that it was done in a professional way, effectively, with good intent, not that everyone was neither party's ever satisfied, not that it was satisfactory to the parties. I must do it. What they've done, they changed a couple of years ago, is they've given me a little bit of wriggle room on that, which means that if the farmer hasn't mediated, either hasn't responded or hasn't mediated yet, and I feel that they've got a good reason for doing so, like there's a good reason why they didn't respond or a good reason why they haven't mediated yet, I'm able to not issue that exemption certificate yet. But then there's timeframes that apply to the farmer. So if, for example, the farmer was incredibly unwell or something like that, and then was really keen, actually, yes, I really, really want to do this mediation. Let's get it organised. I wasn't in the right headspace or whatever. I just physically couldn't do it because I was in hospital, what have you. I'm just spitballing examples here because it's left up to my judgment. If I think there's a really good reason that they haven't, and they're going to now, I can actually say, well, I'm going to hold off on issuing an exemption certificate. Let's get a mediation started, quick sticks. So again, that's not a endless piece of string that delays it on. There's a time constraints within which that needs to happen. But what it does mean is it allows me to use my judgment. If a farmer then puts their hand up at the last minute and goes, no, I really do want to mediate, and they had a good reason for not doing it until then either. So prohibition certificates, we've only received, since it came in a couple of years ago, we've only received a handful of prohibition certificate applications from farmers. And indeed, I haven't actually been required to exercise my decision making on issuing those. So we actually haven't issued any. The ones that we have come across our desk have jurisdiction has been in question. So the financier would say, we're not following the farm debt process because it's not a farming operation or it's not for farming purpose. And then the person who's applying to us, the person who's doing the farming work, have said to us, no, we are actually a farm, we are a commercial operation. And there's some interesting ones in terms of invariably mixed businesses. And then I haven't actually had to turn my mind to exercising my statutory powers on that thing of deciding, is this for the primary purpose of farming or not, because those particular ones that have come across our desk have been otherwise resolved. So it hasn't actually been tested, but it will be interesting to see over the course, as the legislation lives on in a longer way and we see more of those around where does the balance lie between, is it actually a farming operation? So that brings us to the end, and I know there was lots of content that I've covered off there. So we've got a little bit of time now for questions, and of course we're here, of course, to help. And sorry, should put up. Bear with me. I'll put that back up, and I'll put our contact details at the very end. This is what happens when I'm the one driving the bus. You've got the contact details there. So our website, which has a heap of information all about the farm debt process. You've got the email address there where you can actually email through questions that you have. We've got great staff taking calls on our 1-800 number, 1-800-878-964, who can answer your questions as well. So without further ado, I might see if we've got Nick, I'm not sure if you've had any questions come through at your end.
Not just yet, no.
Okay. Okay, well, if please feel free to pop your hand up if you can, or pop it in the Q&A that Nick has set up, which is just at the top next to the chat. And please just remember we are here to help. And look, a little bit of a special plug for our broader work is that we've got really broad jurisdiction to help small businesses in Victoria who are involved in largely any kind of commercial dispute. As long as one party is a small business, not defined, you're the best judge of if you're a small business, which I'm very comfortable with. And it's not a retail consumer or employee dispute. Basically everything else we can cover. So we can help with any business to business disputes. We can also assist if you're having issues with government or government instrumentalities or large organisations or what have you. In the financing space, there's some stuff that we would refer you to AFCA, to the Financial Complaints Authority, because they've got mechanisms. But anything that could touch small business, we're here to help, both from an advocacy point of view and then also from a dispute resolution point of view as well. I think I just thought, yeah, so yeah, absolutely. Great question that's come through. Thank you, John. Yeah, sometimes it is machinery, absolutely. And sometimes the amount of money in default is not a large, as in arrears, is not a large amount of money. Property is a really common one. And it's as you all know, it's not uncommon for it to be a particular title within a broader kind of property landscape. But absolutely, machinery, tractors, 100%. They would be the sites of things as well too. And often that can be a mix of things as well too. So it's not uncommon for us, due to the complexity of running a business, and then also overlay that a farming business, for multiple loan facilities to be involved, and then the asset pool getting talked about. And those conversations in those types of ones in the mediation are really pragmatic, because as you would know, that there's differing things between owing someone money and them having a proprietary interest in your asset, and the two don't automatically follow. But generally the conversations, if there are multi-assets and multi-facilities, and they're more focused at a pragmatic level as opposed to the actual collateral. They care about what they have the proprietary interest in if they have to take enforcement action, but usually it's kind of like everything on the table, from a solution focus. So it might be that it's secured against the land, but well, you've got this tractor, if you've got this machinery over here, if you sell that and pay down your arrears, that could be something that could be explored as well too. Well, if there's no more
questions.
Oh, sorry. Yes.
Sorry, we have one question from Fiona French. She asked, is there an average time frame from first being approached for mediation to the mediation occurring?
Great question. So at the moment, in terms of we take a creditor perspective, so when the creditor lodges their request for the process to start with us, at the moment, because of, there's not surprisingly, sadly, high demand for our services right across the spectrum of what we do, it's around 16-week wait for us to then be able to sort of action that. But once we actually get it, so once you're engaged, we contact either you from a farming perspective or we're talking to the financier, mediation can be organised very quickly. It's just there needs to be enough time for the parties to be prepared so that they can have a really honest to goodness good conversation, and prepare financials if they need to, and forecasts, and availability of the right mediators and rooms. But we've organised mediations like the next day if we'd needed to. Usually what it is and it's people's diaries and availability and things too. So usually it's probably a couple of weeks, probably. We try and avoid doing, oh my gosh, your mediation's tomorrow, because we don't find that puts people in the best headspace. So once you work through, unfortunately, the wait times currently to access our services, it's usually very quick.
And a follow-up question, Commissioner. Fiona asked if you encourage the exchange of position statements prior to mediation.
Absolutely, absolutely. Right across the board, like it's not mandatory, but our mediators think it's really helpful because and one of the key things that goes to the very core of the ideology sitting behind mediation is standing in the other person's shoes and trying to understand where they're coming from and trying to think what's their outcome that they would be looking at. And where's this Venn diagram in the middle where we can get an outcome, not that we necessarily like, but that we can both tolerate. So position statements can be incredibly helpful. Part of the advice we give in that spaces is also for it to be as I can't think of the right word right now, but as vanilla as possible. So honest and well informed, obviously, but not throwing rockets across to the other. Sorry, it's a terrible analogy to use, but not throwing barbs across to the other side as well. If you can have a position statement that is relatively objective. Help me out, Nick. What's the right word? Like I'm just trying to think. That's neutral, that sets out the factors neutrally. They're the ones that are generally the most powerful, because if you've got a party who's then reading sledges about themselves, or there's extra emotion and stuff added in about you did this or you didn't do X, Y, and Z, and if it's too emotive, that then puts the other side, because even large banks, they're human beings that you're actually negotiating with, not the entity, so to speak. That puts them offside. So position statements are absolutely worth the investment of time.
Oh, thank you, Commissioner. That looks to be all the questions.
Fantastic. Well, thank you so much, everyone, for dialing in today. And for those who are watching this later as well, please don't, as I said, don't forget that we're here to help. We can help with a broad range of things. And the most important thing in this space is reaching out to someone for help to start the process as well, if you think you do need a hand. But thank you. Sorry, just one quick question. Feel free to jump off if other people need to. Do creditors contribute to farmers' legal costs or accommodation costs? That's up to negotiation between the parties in terms of what might be suitable for a resolution. We've had situations where, and I'm assuming that might mean if they're coming to the mediation, if that's what you mean by that, Jacqueline, it varies. Sometimes we have farmers who won't pay the $195, and we have the banks who want to pay the $195 because they value the process so much. So a whole range of different things can be agreed. Legal costs probably wouldn't be as legal costs getting paid wouldn't so much be a feature of what we see. But one of the beauties of alternative dispute resolution is you can put all these things on the table. And if a bank is motivated in a particular way and they think there's commercial value in some of that sort of stuff, they might be open to it. But generally speaking, there's no obligation on them to pay those costs. But we can certainly too, we're flexible about organising mediations anywhere around the state as well. We can organise that too, like if it's so accommodation's not required. And we cover all the mediations. Mediators costs. So the mediators heading off in a car or what have you into the region and staying in a motel or what have you, then we cover that. There's no expense to the parties for that either. That may well change over time, but I'm trying to figure out a way in which I can apportion those costs to the party with best capacity to cover those costs. So, I'll leave that there. And I think, Nick, that's it, I think.
Yes, that's all now.
Awesome. Lovely. Well, thank you again so much for your time, and please don't hesitate to reach out to the Victorian Small Business Commission for any help that you need.